Janet, and thank you to BOMA of Metro Detroit for making this program available to its members. Well, everyone has been living through the same thing, and this pandemic has created learning experiences. Our goal today is going to be to walk you through some of the things that we've learned looking at various aspects of real estate transactions and office leases, et cetera, and also looking into the future to see what can be done both with your existing documents and also those future documents that you may be creating. Some people may be suggesting that as we near the end of the hopeful end of this pandemic, that maybe all of these issues are just going to go away, that life is going to return to where it was before. As Alan and I look into our crystal ball, what we see is that nothing is ever going to be quite the same, and that we have different behaviors that people are learning, different uses that people are experiencing, and different ways to make money. And all of those things are going to find their way into how we contract into the future. Alan, do you have anything to add to that intro before we get into the substance?
No, I think we should fire away. I would just like to say I appreciate everybody for joining us. I appreciate BOMA for putting on the mega seminar despite the pandemic that's going on in a virtual way. And again, just thank everybody for chiming in and participating. Why don't you fire us off, Paul?
So we've identified a number of topics that I think have kind of a universal impact. And we're going to be talking about those, and then we're going to be talking about kind of the past, and then we're going to be talking about the future. And the first thing that we want to talk about, just like Julie Andrews, the very best place to begin is the beginning. And that would be the commencement date of your lease. And both for past, present, and future documents, we're always going to be concerned about what those dates actually are and how they may be impacted. Most recently, we have found that it could be difficult to start the clock based on how a premises could be prepared. We could find that we are having a difficult time delivering a premises because an existing tenant hasn't vacated. We could find that the court systems are clogged so that we can't take steps that we might like to take. And not just that we would like to go to court, because nobody really wants to do that if they don't have to, but the reality is that if everybody is aware that the court systems aren't as fast as they might be, if they are ever fast, they're even slower now, and parties are able to game the system. So we're aware of those things. The point of this bullet is to make sure that when you're looking at your deals, you're not just looking at a checklist that you may have always had, but you're recognizing that everything has been impacted by the pandemic, whether it's the timing for getting permits or entitlements or bringing contractors to a site. All of these things are impacted, and therefore those things that we might normally think of as being no-brainers or easy to accomplish in 30, 60, or 90 days may not be so. So we're making sure that our documents take all of those considerations into account, and we know actually what happens when there is delay, because we're always going to be better off when we actually know and have discussed in advance what happens in the case of delay. Alan?
Thank you very much. Let's move on to timely payment of rent. Obviously, that's an issue that is always impacted whenever there are issues, and the pandemic is no different. You may have slow pay, you may have partial pay, you may have no pay. And when you have those type of issues, you need to obviously work with your tenant if they're in a situation where they have the ability to catch up or to otherwise solve the default. Certainly, your tenants have legitimate issues with respect to the payment of rent. In the past, When a tenant couldn't pay rent, there was no forgiveness in general. It was a situation where if you can't pay, then I'll find somebody else who can, and I'm going to kick you out. In today's climate, we can all appreciate that if your tenant didn't get enough PPP money, if your tenant really is in an industry whereby they were hurt by the pandemic, that they may have very real business issues on their end. Doesn't mean they're not a company that won't be able to continue to pay you rent for the next 5 or 10 years if they're a solid company, but it may mean that you need to work with them. And certainly many landlords, the smart landlords, are working with their tenants. We're going to talk about strategies in the second part of this presentation, but with respect to the timely payment of rent, what has happened frequently, and I'm sure many of you have done it, is rent deferral. Rent deferral does not mean forgiveness. It means that I am going to defer rent, either that you didn't pay me during the pandemic in 2020, or that you can't pay me right now because you're just reopening and you don't have the capability of doing it. And ultimately that rent can, instead of be forgiven, it can be moved to a later date. Maybe you bootstrap it into a rental payment in 2022. Maybe you even say we're going to restart it in 2023, so that instead of paying you $2,000 a month, which they can't afford, they pay you $1,000 a month now, and that other $1,000 is payable at some point in time in the future. You can certainly tie personal guarantees into that obligation to pay the deferred rent to give you security. You could even say, you know what, instead of deferring the rent, I'm going to use your security deposit. And you have a $2,000 security deposit. I'm going to use that security deposit now to offset your default. And what I'm going to do is you're going to, instead of deferring everything, you're going to replenish that security deposit again at some point in time in the future. So using money that the tenant has already provided to you, is in your possession, and then requiring them to replenish it is another way to kind of deal with the timely payment of rent issues that are frequent. And if you're fortunate enough that you're thinking, why are these attorneys talking about payment of rent? I'm getting paid on time by all my tenants, then you're a very fortunate landlord, and don't look the gift horse in the mouth. Paul, let me go back to you for the next one.
Well, I guess before we move on, I would just say that, you know, those of us who've been around, we kind of remember the last cycle. And so I would say that I guess a key takeaway on that deferral situation is to try and make sure that the deferral doesn't turn into an abatement, because it could get leveraged into it if it's allowed to grow and people don't document it. Problems don't tend to go away by themselves. And the other thing is that we want to perhaps leverage these deferral requests into an opportunity to review leases. So when Alan brought up the possibility of a credit enhancement for the deferral, maybe there wasn't a guarantee before, but maybe there will be one now. Maybe there were things that should be updated in a lease. So if you are going to be doing what we're talking about, which is providing a deferral, which may be a sound business decision, we should still look at the value of the opportunity to really look at this and recognize that you could end up forgiving deferred rent later. We'll be talking about the deferral bubble, but also, you know, if a tenant owes you money, it could end up being negotiated for the exercise of an option to renew going forward. There are just all these things, but the point is document it.
Yep. And one quick thing, Paul, got a question here. I don't know if it's on the chat or not. If you have a CMBS loan and you can't amend the lease, in other words, you have an issue with respect to deferrals or abatements, and you simply can't deal with it outside of the lender's consent, the question is, you know, how do you deal with that situation, in essence, where you don't have complete control, that you have a lender that somehow has control of your mortgage and over your building? The answer to that, from my perspective, is to work with your lender. Your lender wants you to stay current. And if in order for you to stay current, you need to work with your tenant. My experience, and certainly this is going to vary lender to lender, my experience is, especially in this climate, the last thing the lender wants to do is be so inflexible with you that you can't make good business decisions with your tenant. And if the lender believes that you are deferring rent, as opposed to forgiving it especially, and you will get it in the long run, it would be my expectation that any lender that's dealing with you in good faith would be able to work with you and address that issue. With that being said, Paul, why don't you hit use access to premises?
And obviously being as transparent and candid as possible, and communicating fully with your lender and the special servicer if you're in that situation. The next point is use and access to the premises. That has a couple of different ramifications. A tenant should have a right to use their space. There's different consequences when they're not. The question that exists in the office setting ends up being whether a landlord may have liability if a tenant is not following whatever regulations there are, use and occupancy, and the importance of discussing those issues with your tenants. We'll also talk about use clauses because especially on new transactions, it actually can come back to bite you where you don't want it to, where you limit the use of a premises specifically and solely to something, which is something that you want to do, especially if you've granted exclusives and there are restrictions, but then that use ends up being prohibited. Have you ended up drafting yourself into a frustration of purpose argument later down the road? So we'll be talking about that. If the point is that you as a landlord, if you're a landlord or you have a tenant, you as a tenant have the right, have an expectation that a premises is going to be compliant, especially if the lease actually says it. And again, there are things that leases say and there are things that leases mean. And so you'll really need to look at those carefully, especially those provisions, and talk to somebody like Alan and I if there's any question in your mind about what courts are doing with them. Alan?
Let's talk about operating expenses. So operating expenses obviously are impacted by COVID. Many buildings have janitorial included, and arguably janitorial expenses could be less because in theory, there may be less businesses in your strip mall that are operating. There may be less occupants in your office building that are there every day. And so in theory, there may be a reduction in the fees to the janitorial staff because there's less to do. On the other hand, whatever the janitorial staff is doing, they're certainly doing more cleaning, they're doing more sanitizing, they have more protocols to go through, and ultimately those operating expenses are increasing as a general matter if janitorial is included from year to year. And that's something to consider because your janitorial is probably not part of your uncontrolled cap. And ultimately that's not necessarily something that your tenants are going to be overly happy about if they have a huge increase in operating expenses, even though it may very well be fully justified in something that before they see the bill, they may be asking you for. Operating expenses also are impacted by the pandemic with respect to air quality, air filtration, and all of the things that have become more important to tenants today than they probably were pre-pandemic. And so depending on the current condition of your system and whether or not you have capital expenses as part of your operating expense definition, you may very well be considering improvements to your HVAC system. All the HVAC contractors that are listening to this are clapping their hands, but you may very well be considering whether your system is outdated, whether your system is competitive in the environment of the comparable buildings, and whether or not you have in your clauses the ability to amortize that expense over time. And of course, most importantly, whether or not that expense can be passed through either fully or partially or with a cap to your tenants. And in terms of future leases, certainly something that you're going to want to make sure is, you have the ability to do, just like if you know you're going to be replacing your roof, or you know you're going to need to be replacing your parking lot, or you got a ton of tuck pointing to do, whatever type of capital expenses you may need to spend, think in advance about whether or not air filtration, air quality, and HVAC are things that you want to modify in the future in your leases, because the pandemic has made those features more attractive to tenants and maybe something that they even expect in the building for the rate that you're charging them, that you're going to have a system of air filtration that is quote unquote state of the art. The other issue with operating expenses is what you do with your buildings and how you're building them out. You may have previously built a very nice enclosed arboretum. And you may have a couple picnic tables in there where people go in there for lunch. Well, that may no longer be as attractive as the picnic table that's in the grassy area near the parking lot that's outside. And it's very expensive to have that indoor area, and it's expensive to maintain, it's expensive to build out. So in terms of what your expenses are in the future, you just want to appreciate that your tenants they may have different needs for the amenities at the premises than they did pre-COVID. And with respect to those needs come a different desire, and obviously how that's going to impact your operating expenses at your property and where you might be able to save money, divert money, or in some cases actually have to spend more money as long as you can pass it through to your tenants. Paul?
Thing that I'm seeing that I think is interesting, but I haven't seen litigation on the subject yet, and it could come up in audits, is there are frequently caps on operating expenses, except for so-called, quote, uncontrollable costs, close quote, which may or may not be defined in the lease. And depending on what those costs are, you may be able to pass those on, a landlord might be able to pass those on, and depending on what they are and the extent, might be advised to pass them on, irrespective of the cap, if the reason for them is because of the pandemic. And of course, that's going to depend on what they are, but that might provide some relief for the fact that there is some cap and unforeseeable expenses. And that leads to compliance with laws and public authorities requirements. So again, this is something that you need to look at your lease for. Many times a lease will say that it's the responsibility of one party or another to make sure that this or that is in compliance with the law, whether it's the premises itself or the common areas or a particular building, et cetera. And when you're looking at common areas, which sometimes contain aspects that are the responsibility of one or another, there could be some interpretation involved. And when it comes time to spending money, I wouldn't necessarily assume that something is automatically just the responsibility of one or another. And this is going to play into the repair and maintenance issue also. But then when it comes to compliance, again, there's a liability issue. So decisions are being made on what a landlord is doing, what a tenant needs to do to make sure that the work environment, the environment for the public is appropriately healthful. That has certainly contractual obligations involved because of what the lease may say, but it also has capitalist consequences because you want to have a place where the public feels comfortable entering, that is, if they're going to be there. And we're going to be seeing more and more of that as it relates to maybe newer space designs in office buildings. We're going to be seeing all sorts of things in the retail space as it relates to curbside delivery and parking ratios, and those kinds of things. And that there's going to be a very interesting future to all of those things. But for purposes of present deals, and the fact that you're making investments into your space and your buildings, you really need to be thinking about whose responsibility these are and the investments you're going to be making for the future.
Paul, I noticed that there was a question. I can't see it as I'm sharing my screen right now. Is there a question in the Q&A to be answered?
Yes, let me read it because I think it's a good question and something that you and I were going to be spending some time talking about later, and it may inform us. The question is, we're seeing some progressive, in quotation marks, jurisdictions trying to pass additional COVID relief legislation in favor of tenants' ability to cease paying rent and canceling legal and enforceable leases, thus putting landlords in extremely adverse positions. Have you seen or do you anticipate this will continue under the current political atmosphere? So I would say that, Alan, let's you and I make sure that we leave some time to address that particular question on the legislative front, because we're also going to be addressing that question on the judicial front in terms of what we're seeing courts do in some of these situations also, because the courts are going to be weighing in on the constitutionality of some of these violations of the freedom of contract principles that we have. But that's a good question, and I think we'll look at that as part of this.
Fair enough. I would just give a quick answer, not with respect to the legislative, but with respect to the judicial rulings. I have not yet seen in Michigan, and that's really the state that I'm focused on. So I don't know if the jurisdictional question was talking about outside of Michigan. I have not seen any what's called controlling, which would be in the Court of Appeals or above, rulings that have precedents that would hold that because of the pandemic, and that's the subject that we're talking about here. Obviously, there's many related topics, that the pandemic itself isn't somehow invalidated contractual provisions that the parties negotiated in good faith. I would certainly be disappointed if I heard of those type of results, and I would think that courts have an obligation to enforce the contracts as written. As we all know on this call, that doesn't mean that just because a contract says something that you can be guaranteed that at the end of the day, that's what the court will do. But from the standpoint of planning for the future, I would at this stage not advise any client or any prospective client that they need to be afraid that a court will, at this stage, invalidate their rights due to the fact that the tenant itself has had some type of adverse impact. That landlord-tenant relationship is governed by the lease, or that buyer-seller relationship is governed by the purchase agreement. And those contracts are intended by all to govern. And I would stand on the mountaintops and shout as loud as anybody could hear me that if a court is going to defeat or contradict the party's intent, then what's the purpose of the parties engaging in a contract to begin with? Legislatively, there may be a different point there.
Oh, and Alan is offering to indemnify all landlords against any kind of adverse judicial decision, right, Alan?
Absolutely not. But
Okay,
I appreciate that. I do appreciate that. As we all know, the court's an unpredictable world, but I think the question is a fair one. And I think the question really says, at least the way I interpreted it is, do you have a feeling that landlords should be negotiating away their rights because they should be concerned, genuinely concerned, that courts will not comply with the contractual provisions? And my response to that would be no. I think that ultimately you can always negotiate because you don't want to take risks and you don't want to spend the money inherent in taking the risks. But do I believe that there is a precedent out there that makes me concerned? No, I do not. But as Paul said, I ain't indemnifying anybody. So, buyer beware.
We will have time to talk about this whole concept of how parties are able to game the system and take advantage of different moratoria and those kinds of things. And there are adverse decisions or tenant-friendly decisions from other states. And I don't know if anybody's ever had any experience of a judge that they thought was tenant-friendly. So stranger things have happened. And certainly, we can all be effective advocates and say what we think should happen. And it's going to be worth Alan's indemnification.
Let me, by the way, let me transition to insurance then. It's an excellent transition. So, with respect to insurance, in the COVID environment, there are many leases that I see whereby a tenant is either encouraged or required to get something called business interruption insurance. And over the last year, my guess is everybody on this call has heard the word business interruption insurance. You as a landlord may even have your own business interruption insurance. For purposes of COVID, landlords should not expect that business interruption insurance is going to cover any virus, disease, or pandemic related issues. Business interruption insurance is designed to cover damage to property or loss to the property itself. Business interruption insurance is generally designed to be for floods, fires, earthquakes, those type of things where your business is interrupted because of damage to the property, not necessarily damage to the employees or the disease. In fact, many business interruption policies have specific exclusion clauses, which are amendments or endorsements to the policy that specifically exclude business interruption coverage for disease or viruses. So to the extent that you're thinking to yourself, you know what, the tenant has business interruption insurance, they should have money to pay the rent. The answer to that is probably not. They may have money to pay the rent through the PPP money they got, either on the first round, the second round, or as of yesterday, now on the third round, which is hugely important to all of us. But that does not mean that their, business interruption insurance is going to ultimately cover this. You do want to make sure, of course, with respect to insurance, with respect to COVID, that you have the appropriate coverage for yourself. Certainly a tenant claiming that they got COVID because your cleaning crew did not appropriately disinfect a certain surface is a attenuated claim that I would expect to fail. On the other hand, if the tenant has multiple employees and it appears that they all went into the same area and somehow they can prove that that area was not cleaned, you do want to make sure that your insurance doesn't have exclusions for disease or viruses. That is something that your insurance very well may have in your general liability or your personal injury policy. You may have never really thought about it before the pandemic as to whether or not there was an exclusion on your policy for, virus or disease related issues because they just weren't on the surface of any of our consciousness prior to a year ago. But I would encourage you all to look at your insurance policies, find out what type of insurance you have. Does it cover the very unlikely event where tenants sue you and claim that, not only do their couple, employees or several employees got COVID, but, maybe one of them passes, maybe their business shuts down. The damages are huge or potentially huge in that concept. So whether or not you're purchasing insurance and paying for that risk to be covered, or whether you are not going to pay for that risk to be covered, you should at least acknowledge that that risk is out there. Gas and smoke type issues are generally not covered by your coverage if it's a business interruption and policy on the landlord side. So if you do want coverage for business interruption due to government related shutdowns or due to disease or pandemics, you also may want to look at your own business interruption policies if you have them and see if you're going to have coverage should you ever need to make a claim due to the pandemic shutting you down, i.e., the governor saying that you're no longer able to operate that strip mall or operate a certain portion of that premises that you own. Paul?
And it's possible that a particular owner might be able to get better business interruption insurance as a package than an individual tenant might be able to. Frequently, leases will give a landlord an opportunity to buy the business interruption insurance, and a tenant agrees to pass it on. Tenants sometimes balk at that because they don't want it. That may be different now. But then frequently force majeure provisions will carve out rent as a force majeure event. And nowadays tenants might be saying, oh no, I don't think that we should have that rent carve out. Well, then the answer might be, well, we might take that rent carve out as long as you provide proof of business interruption insurance. So that can actually be a negotiation, but I'm not sure that insurance is ever going to be available or affordable, like Alan's talking about, unless the federal government creates some kind of backstop program like they did for terrorism reinsurance. The next subject is on repair and maintenance issues. And again, it's whose responsibility these various things are, but also whether or not maintenance actually means upgrade responsibilities. So if there's a new requirement, then and an existing fixture can't deliver whatever it is it's supposed to deliver under new government or regulatory or code requirements, then whose responsibility is that going to be? And that's really a discussion point on each individual matter. But the failure to act appropriately could also be a default under a lease and also create leverage under a lease. So it's just something, again, that parties need to be aware of, beyond the fact that finding trades available to provide whatever repair and maintenance may also be a challenge these days, and something that needs to be put on the checklist.
Let's move to eminent domain and casualty. Eminent domain, for those that are not familiar with it, is in short a public body, a governmental entity that feels that there is a need for the general public to acquire either personal or real property. Under the law, that government entity that is acquiring that real property, maybe to put a road in, or to put utilities in, or to otherwise develop the area for a larger purpose, is required, of course, to pay reasonable compensation to the owner of the real or personal property that they are, quote unquote, taking. The reason eminent domain is in here is that it is foreseeable that because when a government entity comes in and they take your space, that is essentially a taking, which is tantamount, of course, to what the government is doing in a eminent domain situation. Ultimately, there's a difference between the government declaring that you can't use your space for public health purposes and the government declaring that they need your space for a public use. But certainly it is foreseeable that you may, deal with somebody making an eminent domain claim on the basis of COVID, that their property was taken because they can no longer use it as they would like. I would tell you that is a very far-fetched claim. I have not seen any of those claims, but I have heard of them. And I haven't heard of any in Michigan, but I have heard of them across the country where, desperate times means desperate measures. And if a tenant is going to allege that their force majeure clause doesn't protect them, and they're going to argue frustration of purpose to try to get rid of the contract, they very well may argue that under principles of eminent domain, their property has been taken and they are entitled to terminate the lease. It's the same concept with a casualty. Again, this is not something that I've personally seen, but it is foreseeable that just like in a fire or a flood, that if a casualty event occurs, what happens to you as a tenant is you cannot use your space until that casualty is rectified. And as many of you have in your leases, you may have a clause that says if 25 or 50% of your space is subject to a casualty, that both parties have a right to terminate the lease. You may have a clause in your casualty that says if there's a casualty that lasts for 2 months, 3 months, 6 months, however long it is, that either side has a right to terminate the lease. It is certainly foreseeable, although again, I have not personally dealt with it, but to make everybody aware of it, in a casualty situation, it's one of the only rights that the tenant has to terminate the lease. And because ultimately, if the government comes in and shuts you down, you will not be able to use your space. The inaccessibility of the space could be argued to be tantamount to a casualty, and a creative tenant could certainly argue that that has resulted in them being able to exercise their casualty right and, make an argument that they can terminate a lease that might have 2, 3, 5, or even more years left on it that they can't really afford because they're really using it as a sword. I have not personally seen that, but it's certainly, again, something to look at in terms of your eminent domain and casualty clauses going forward, is to clearly define that they are the basis of floods or fires, that your force majeure clause deals with force majeure events like a pandemic or an epidemic or a disease-related or a government-related shutdown. It's more important to ever than to look again at your eminent domain and casualty clauses that you may not have looked at in a while and make sure they can't be unnecessarily extended to an unintended result and give tenants rights to terminate that certainly you didn't intend. And as I said, desperate times call for desperate measures. If your tenant needs to get out and can't afford it and wants to try to avoid bankruptcy, they may very well be looking at those two clauses as a sword to use against you. Paul?
I would say that that would be an act of desperation if those were the only things that somebody was relying upon in a particular scenario, because there would also need to have been insurance, but that's risky business if that's the only thing that somebody's going to be relying on. But in Michigan in particular, the eminent domain point is actually a real one, because there have been challenges to the power of the government or the governor to do what the governor has done as it related to certain industries. So we are seeing those arguments being made by the movie theaters and by health and fitness centers that experience the greatest shutdowns. And I guess we're gonna see what the courts do with any of that, further to the question that was asked earlier. On notice provisions, just a practical one with so many people working remotely, it's become the case that providing notice to tenants in the normal way you might, by stopping by to say hello and dropping off a letter, isn't necessarily working all the time. And so definitely an opportunity to update notice provisions, to clarify what happens when there's been a failure to operate on site for any kind of prolonged period of time, what kind of notice can be sufficient for different kinds of default notices, or any other kind of notice that might be required under the lease. So that's just more practical than anything else, because the COVID did not make it so that nobody has to provide notice anymore. It's just going to be more of a challenge to be able to prove and provide actual notice.
All right, let's move to our kind of the overall topic with respect to strategies. So I'm going to kind of talk on the strategies with your existing tenants. Paul's more going to focus on your strategies for your future leases or your future tenants, just as a kind of a breakup of the two of our kind of subpart presentations on this slide. You kind of see them all there. I can tell you that I have seen all 7 of those things occur in my practice. And if there's any of them on that list that you haven't contemplated, they are all strategies that can work. We talked about deferred rent previously. With deferred rent, less attractive to landlords is partially forgiven rent or fully forgiven rent. Certainly, no matter which one of those strategies you are forced to endure, you would like to get your pound of flesh back if you can. And if you have to forgive rent, then I'm hoping that you got a personal guarantee. I'm hoping that you got some security. I'm hoping that you got a lease extension. I'm hoping they exercise their option. I'm hoping that you got something back in return for your, essentially, your ability to work with the tenant. If you got none of that back, then it means that you needed their cash flow. They're a large, important tenant. And at the end of the day, you may have taken the brunt of it. I would suggest to you that if the tenant is saying that they can't afford anything, that you remind them that there was a brand new round of PPP money that was just put into place yesterday. Ask them if they are applying for that money, if they have gotten the second round of money yet. Sometimes tenants, admittedly, are hoarding that money. And even though they say they're using it for rent, the reality is there are not as many checks and balances put into the PPP program once the money is there as we'd like from the landlord's perspective. So no reason why you can't ask the direct question. And certainly you could, go to the nth degree and have them sign an affidavit, have them make affirmative representations and warranties to you on what they got, what they're going to get, and conditionally in the future, if they do get money, how much of that money they're willing to give to you. Once they sign that and they represent it, it becomes an enforceable agreement and you can use it as a sword if you need to in the future. Just quickly running through the rest of these, modifying the premises really means shrinking the premises. I have yet to see anybody expand, but that would be sweet. It really means right now you're in whatever, 2,000 square feet, 5,000 square feet. Maybe we could cut that down so that you can afford your space and we can try to rent out the remaining space to another tenant. Relocation, again, is not really relocation to the same space. It's really relocation to a smaller space. That has worked. That's a working, especially if you have an attractive location and an industrial location, especially where you might be able to find a new tenant quickly in this environment. Relocation to a smaller space can really be mutually beneficial. Sometimes switching the uses, as Paul said, if your use has been beaten down by government regulations or your use isn't really, for instance, in a strip mall, isn't really conducive to the COVID environment. Maybe you're a tanning salon and you're getting less use because people are more aware of sanitization and cleanliness. Changing that tanning salon into a different type of business that doesn't have the same restrictions might work out. Certainly your tenant that says that they can't make the rent, fine. Find me a new tenant. You can sublease it to another tenant. You find me another rent paying tenant, I will assign it. That sounds great. Lease termination fee. I'm not going to defer the rent. I'm not going to forgive the rent. I just want you out. Let's figure out how much you can pay. Let's figure out how long I'm going to take it over. And you'll pay me this lease termination fee. Normally, a lease termination fee includes an accelerated debt amount. So I'm not suggesting that landlord should take 5 if during the term of the lease 25 is owed, unless they get the 5. And so I would suggest that your lease termination fee may be 5 and you're willing to accept it. But if there's a default at any point in time in the payment of the 5, that you have a right to accelerate the debt owed to the full 25 so that there's an incentive for the tenant to make the payment and there's a more likely basis they'll make the payment. Obviously, renegotiating lease terms is generic. And if you have to, you can evict tenants. As Paul said, landlord-tenant district court actions are behind. Some of the courts are behind weeks. Some of them are behind months. And so evicting a tenant is problematic because it's costly. It can be a pain. But now there's the added dimension of it can be more time consuming than you thought. So just some strategies and things to kind of think about as you're dealing with your current tenants that have claimed COVID related issues. Paul?
Thanks. So what we're looking at for the future, I think is going to be a premium that's going to be paid for the ability of the parties to be flexible. One nice thing about a contract is it's a contract. It's something that people can rely on. And the problem is when the circumstances upon which the contract were based really change, then parties may need flexibility that they wish they had, but that they don't. And so I think what we're going to be seeing in the future, and something that we should be thinking about in advance, is what kind of flexibility does a party need, and what kind of flexibility should a landlord, for instance, be willing to provide? And there's nothing for free. So the response to requests for exit strategies, as they're called, where somebody wants to be able to modify their premises, or somebody wants to maybe have a downsize opportunity. All of those things may be possible, and they may not be automatic no's. We just have to have a way to monetize those requests. So always being aware that if there are dollars spent, they can potentially be recovered. If somebody wants to be able to terminate early, maybe there's going to be a sales kickout. Maybe the sales kickout in a retail setting isn't just an automatic situation. Maybe there's a termination fee to be paid with that sales kickout. So these are the things that we need to be thinking about. And we also need to be mindful of other issues like co-tenancy rights. So a co-tenancy may be something that is a necessity for a particular tenant, but the exercise of the co-tenancy right could trigger a world of hurt for a landlord, because there could be consequences based on losing an anchor, or falling below a particular occupancy requirement. All of those things can be factored into a formula, because the idea is still going to be to get deals done. We just want to get deals done in such a way that they're going to be good for everyone. So an owner is still going to be able to make money and have a bankable lease. A national tenant still has to be concerned about Wall Street. And so we still want to get deals done that make sense for everyone. So our crystal ball on this is that there is going to be greater demand for exit strategies, but there are also going to be creative solutions to making those exit strategies possible. We're going to be seeing a greater demand for flexibility and assignment provisions, because tenants are going to want to be able to assign or sublease their spaces more easily. Well, that may be okay. We're now going to spend time identifying what an appropriate replacement tenant can be. We've seen situations, as I mentioned earlier, where a landlord actually ended up being hung on its own petard because a tenant could only use a space for a specific purpose. And because that purpose was no longer available, there was a sympathetic court. But if a lease is now revised or drafted for future leasing, so that in addition to the principal permitted use, there is also a recognition of ancillary uses. So we always know we don't have a problem with tenants having related ancillary uses, but it's possible that the lease is only written because the lawyer only wrote it, or maybe there wasn't a lawyer involved, and it says use, pizzeria, and nothing else. Use, shoe repair, nothing else. Well, we really wouldn't mind if there were shoe supplies sold, or maybe, other things that were ancillary to it. But a tenant with a poorly written lease actually ends up having that lease written into its favor because it says solely. But when we write in what we know is happening anyway, which is ancillary and incidental uses that are related to the primary use, we've now avoided the problem, a potential problem of frustration of purpose. So we're looking at our leases now in the future to anticipate what we're seeing, which is the potential that our government's gotten used to the ability to regulate use and occupancy in a way that they haven't before. And we are seeing some sympathetic court decisions, thankfully not so far in Michigan, but my firm, and I think Alan's firm, practice in many more states than just Michigan. And we're seeing these crazy cases in other places. And so we do have to anticipate for you how you can best protect yourself. And our crystal ball is you're going to need safety in the future. You're going to be needing to build in some of these protections to avoid these problems. So I think that's all I have on that in terms of being visionary, but we could spend a minute talking about some of the legislation that we're seeing in other states. And frankly, there's also been some helpful legislation that we can tell you about too. And if anybody has any questions that they want to put in the Q&A or the chat, they can. But let me just kick off the discussion on legislation. There was recently legislation passed that would be favorable to landlords who are providing rent deferral, because there's been some concern that tenants paying deferred rent could end up being part of a claw, or landlords could be part of a clawback when that deferred rent was paid. And Congress passed, as part of the last program, an amendment to the bankruptcy law, so that for the next 2 years, payments on deferred rent agreements are not considered preferential under the bankruptcy law. So that's a good thing. However, we do know that the laws that were passed recently or the regulations passed by the CDC, which gave rise to a moratorium on evictions and those things, have been challenged successfully in Texas most recently, and New Jersey a little bit ago. Now, there wasn't a stay of the effect of the moratorium, so it's still winding its way through the courts. But there's this genuine issue of what's, we have the contract clause of the Constitution. So theoretically, courts and legislatures or agencies invading the rights of landlords to pursue remedies under leases is a pretty much of a problem, and one that, it's not going to ultimately stand the test of time, I don't think. But as Alan and I were talking about, there's a game that's been going on, and that is, how can we delay, and in whose favor does delay work toward? And the more there's a moratorium, and the more there's a backlog, and the more there's an issue, and the more there's uncertainty, the more it works towards people who want to have that delay, and that's usually the people who don't want to honor their contractual commitments. So I don't think that the legislation is going to ultimately be successful, but it buys time, and time does not work in favor of people who have lender obligations. And that's a problem. Alan, do you want to add to that?
No, I think you covered it. I'd love the opportunity to, if there are, I don't see any other Q&A type questions. I'd be happy to, Paul and I are happy to answer any questions that you have on any of the subject matter that we discussed through this presentation, or any other questions that you may have relating to, legal issues dealing with your commercial property, retail, strip mall, office, etc. If you don't have any of those, then certainly I'd be happy to, we're almost at the end here, Paul, kind of wrap it up. I do have, a question for you, Paul, if there are no others though. Janet, would that be okay for me to ask Paul a question?
Go ahead.
I don't have to answer.
Paul, I heard a rumor that you dress like that every day and you go to your office every day. That was awesome. And the Janet screen did not just come up there for anybody. That's a visual thing. Is it true that you dress that well every day and go to your office every day, despite the fact that no one gets to see you except on this Zoom call?
As I tell everyone, officers and soldiers in the Army function better in uniform. And we are in a war, and I'm prepared to fight every day.
Dude, I love that. Can we please close with that, Janet, if there are no other questions? And I couldn't agree with you more. The professionalism goes without speaking. It's been a pleasure to present with you, Paul. I thank Janet. I thank Sharon. On behalf of Paul and I, we thank everybody for attending. We hope you found it to be helpful. Paul and I obviously are long-term BOMA members. Paul is a former BOMA president. We certainly encourage you, if you have other questions, to seek whatever legal counsel you may find to be appropriate. Paul and I throw ourselves out there as able-bodied attorneys to assist you, but there are also many other attorneys in BOMA. We hope that you, seek legal counsel when you need it, and we hope you found the presentation to be helpful.
Thank you so much, Alan. Great working with you.